Hello. Mic check. Mic check. Is this thing even working? Is this thing even working? Hello, everyone. Hello. Just doing a quick little audio check. Sorry. I was trying to do one in the background and it wasn't letting me. How's everybody doing? Welcome on in. Good to see you. Good to see you. Hi, everyone. Diane Draper, hello. Michelle, hello. Teresa, Kaleido hello. Beach Babe, welcome, welcome. New Mexico, 444. Hello, Amethyst. Anna D, hello. Okay, let's see. Redacted Meanie. Well, hello, Redacted Meanie. How's my audio, guys? I've been doing all kinds of things in the background. I made adjustments. I followed the steps. I fixed some things. If it sounds bad, let me know. If it's clippy, choppy, please let me know. Now, I would truly appreciate it if you did. Um, just helps me out and we don't waste anyone's time, you know what I mean? Paco, hello. Deb, hello. Gracefully salty, Meg. What up, gangsta? Beautiful Meg. Hello, honey. How's the audio? Tell me now. Clippy, choppy, and don't lie. Thank you, user Deb. Cutting out. Okay, hang on, honey. Okay, so we've got some people saying the audio is perfect, and we've got some people saying it's choppy. Okay, how is it right now? Is this any better? I'm checking background right now. Let me know if this, okay, everybody's saying it was good. I love you guys, but sometimes, I feel like you lie to me because when I go back and listen, it does sound clippy and choppy. Okay, a lot of people are saying it sounded good. How does it sound now? I think I may have had it like on the wrong mic setting. Still good. Sound is great. Audio is perfect. You guys are awesome. Okay, perfect. Danger. Oh my God. Where have you been? I hope you are well. Missed you so much. Miss Q, how you doing? Blueberry the Great. Batsheet. Harry. Okay. Audio's good. Audio's good. Perfect. Went back a bit and forward. Okay, okay. If we're good now, we're good now. Perfect, perfect. Danger. Watch yourself. How you been? So good to see you. So good to see you. How's everybody doing? Happy Monday. Thanks for being here. Hope you're having a great day. It's almost Thanksgiving. Have you been thinking about all of the things that you're grateful for? Have you? Probably something to think about. Blueberry the Great, big pimpin' on the mic. Well, let's not pat ourselves on the back too fast yet. You know what I mean? Speaking of too fast, where's too fast for fleas? Where's too fast for fleas? Hope everybody's doing well. Hope you're having a great Monday. I figured this is something that we've been getting a lot of questions about around the community here, right? Everybody's been talking about, oh, appeal, and what can be done, and blah, blah, blah. So that's what I wanted to talk about tonight. And, nothing crazy. Just look at a few things together. You know what I always say here. I do not know shit. Do not listen to me. Uh, Exercise due diligence, do your own research, read the docs yourself, and come to your own conclusions. I just like to hang out, nerd out, and there's a lot of cool people in this community that also like to hang out and nerd out. So that's what we're here to do. We're here to nerd out and snark. That's what we do here. If that's not your cup of tea, you should click right on out. But welcome on in, everybody. Mods, thank you for being here. So, I know, everybody's been talking about it, right? Could Mr. Kohberger appeal? And if so, how, what, etc., right? Um, I've kind of looked at it. Leslie. Oh, well, hello, Leslie. Oh, you know what? Actually, before I even get into this, last night, Outcast. Wherever you are, Outcast. Okay. I had the worst bout of insomnia last night. And it was like, I don't know, midnight or something. And Outcast was live and he was doing that true crime Jeopardy and Outcast feud. And I got to tell you, it was probably one of the funnest nights I've had in a long time. So thanks, Outcast. Big shout out to Outcast. If one of you don't mind, mods, drop his link in the chat, please. Would really appreciate it. We had so much fun last night. Leslie and Billy was my partner, and we kicked ass. And it was a lot of fun. It was actually a lot of fun. So, yeah, looking forward to that. Apparently, Outcast does that on Sundays. They try to do like Sunday Fun Day. So, um, I don't know if that was first time last night, but he should continue doing that. It was a lot of fun. Michelle, I can't put my DNA on the like. Oh, I don't know. I don't know, honey. Couldn't tell you. Megstar was in the chat and won. Yeah, that's my girl. Get it. Get it. Is this thing even connected? What's it doing? I'm on Rumble, friends, obviously. I'm live from Rumble tonight, too, because StreamYard blows. So it looks a little different on my end than StreamYard does. Big Booty Judy. Welcome on in, Big Booty Judy. Love the name so much, actually. Big Booty Judy. Amazing. It's amazing. That's an amazing screen name. I love it. Big Booty Judy. That's hysterical. What is this thing doing? Let me see here. Oh, wait, Annie, get it together. That's why. Thank you, Meg, for dropping Outcast link. Appreciate it. Look at this Booty Judy. I love this name. This is amazing. Redacted Meanie. Yeah, it was a lot of fun. Yeah, it was a lot of fun. If you are not subscribed to Outcast, you should be. And, a lot of Outcast is really late night streams, so I miss it. But like I said, last night I had insomnia pretty bad, so I was up all freaking night. I didn't fall asleep till like 4 in the morning, which is wild for me. But it does happen like once a month, so that's what it is. Once or twice. Double Trouble MP. I love this Big Booty Judy name. Like seriously, I can't get over it. That's hysterical. It's one of my favorite names that I've seen so far for screen names. Big Booty Judy. It's hysterical. All right, so let's see. All right, I know we're going to nerd out on some stuff. Obviously, if there's things you guys want to talk about, we can talk about it. Um, as long as audio holds up and things seem to go well, I may drop the link. You just never know what's going to happen. Mods, this chat is wide open. I have set no restrictions. Actually, maybe we should. Hang on, friends. Let me just do that right now, actually. If my phone interferes with my mic, sorry. Hang on. I should probably fix my chat, though. Hang on. Okay, let's see here. Do, 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 do. That way, my poor mods, they don't have to work too hard. You know what I mean? Make the night easy for them. Okay, here we go. Let's fix this. Gonna fix this. Participation mode. Well, it's going to be subscribers only for 10 minutes or longer. That way, they have to subscribe and wait 10 minutes to leave a stupid comment. And that says more about them than it does about me. And then we'll fix that. And all of y'all, I love you. But I'm going to put it at 10 seconds. So you can only slam a comment in every 10 seconds. Okay? So sorry. So sorry. I know that that's rough. Okay. There we go, mods. That should be fixed for you now. Appreciate you. Truly, I do. All right. All right. Let's get into this. Meg. Oh, Jim. Yeah. Yeah. Jim may pop in. If Jim pops in, we'll drop the link for him. It's fine. Stephen Fillmore. Hello. Welcome on in. Hello. All right. If I missed anybody else, so very sorry. Okay, so I know I titled the live, Will Brian Appeal? Could Brian Appeal? Etc. We'll look at a few things. Bootsy. Yay. So good to see you. Thank you for being here. Oh my goodness. Haven't seen you in forever. All right. So let's see. Okay. This is one of the things I wanted to look at with you guys. Now, as you know, okay, if you're new here, when I go into another window to read, I can't see my chat. So, appreciate you being here. Chat amongst yourselves. If audio starts getting crazy, you got to throw some red flags up and shit. And I'll try to keep my eye out. Actually, I know there's a way for me to pop out my chat so I can see your red flags. Hang on. Hold, please. Is it that one? Which one is it? Now, whatever. I'll periodically check. I don't feel like trying to figure it out right now. All right, here we go. So the link for this is posted in the description. It's from findlaw.com, and it's all about appealing a conviction after pleading guilty. Now, obviously, we also know we have habeas corpus, right? Which is also something that we can read. But the two things that we're going to look at tonight is this and the other thing that I have to show you. It's a 29-page PDF. But it's all about challenging unjust convictions under Section 1983. We don't have to look at the whole thing, but there are a few things in here that I feel like possibly could pertain, especially when I was reading about like treatment in prison. And some of the things that were there kind of gave me a giggle because we know he was moved, right? Wasn't he moved recently? Due to his complaints about his food, if I remember correctly. Is that accurate, mods, Meg? For fuck's sake, Fitziana, if you're here listening. I feel like wasn't it just recently he got moved due to his like complaints about his food? Maybe that was a dream. Maybe I imagined that, but I feel like I didn't. Why do I feel like that's factual? I'm going to look it up right now, although it might interfere with my stream here if I do. But I feel like he was recently moved because of like whatever. Remember his complaint about his food or whatever? Is that correct? If I'm wrong, I'm so very sorry. Maybe I did literally dream that shit. I mean, it could be just I could be having like the same issue that Dylan was having, where I thought something was real and it wasn't, and that's totally fine if I am. Redacted meanie. I heard a creator mocking him for complaining about food, bananas specifically. I'm not sure, honey. Mary Holt, hello. Good to see you. Welcome on in. Okay, so yeah, he was moved, yeah. Like not out of the to a different part of the prison, correct? He wasn't moved out of Idaho maximum security, just moved to a different section, correct? Still in the same place, just a different section, if I remember correctly. But don't quote me. Yeah, another cell. He was getting harassed through the air vents. Thank you, Amethyst. Good to see you, honey. Okay. Well, thought it was something about his food, too. Something to do with, like, them fucking with his food. I don't know. Or that the food wasn't what he was requesting or something. Part of his dietary needs or whatever. Something like that. I know he was complaining about it. There were complaints. Jack B, hello. Good to see you. Different cell, same block. Thank you, Mama J. Appreciate you. So I didn't imagine this. This wasn't a dream. Good to know. I'm very happy to hear that. Okay, let's get into this. So, appealing a conviction after pleading guilty. Pleading guilty to a crime is usually a done deal. You often can't take it back. Yet, some problems, such as rights violations or police intimidation, may justify reversing your plea. Get that out of there. The Constitution guarantees criminal defendants the right to due process and a speedy trial, which they fucking waived. Sorry, for my side, one sentence. I'll start over. I will try not to do too many side. The Constitution guarantees criminal defendants the right to due process and a free trial. If you end a plea agreement, you must tell the judge in open court while under oath that you want to give up these rights and plead guilty. Neither the judge nor a jury will decide the factual issues and legal questions. All that's left now is receiving your sentence. But after pleading guilty, you might wonder whether that was the right move. What do you do now? It's essential to always understand your trial rights, the consequences of a criminal conviction, and the maximum time behind bars you are facing. Never let anyone pressure you into pleading guilty in a criminal case, and always seek the advice of an experienced lawyer. Below is a brief explanation of the feasibility of appealing a conviction after entering a guilty plea and the standard for withdrawing your plea. Plea withdrawal, good cause required. It's important to note that, quote, buyer's remorse, end quote, is not a good reason to withdraw a guilty plea. You can't simply change your mind later. It's a harsh reality that requires serious consideration. Sidebar, do you think there was serious consideration? Because it felt super fast. I was literally in Pennsylvania covering all of the defense witnesses that were subpoenaed in PA. I drove to Pennsylvania to be there at the hearing to cover it. And literally that I left the hearing and within the hour it was announced the plea. Anyone remember that? Pepperidge fucking Farms remembers. Okay. All right, let's continue reading. Before you enter a plea, the trial judge will ask whether you understand the constitutional rights you are about to waive. You will attest that your plea is voluntary, knowing, intelligent trial waiver. Blah, blah, blah. Before you enter a plea, the trial judge will ask whether you understand the constitutional rights you are about to waive. You will attest that your plea is voluntary, knowing, intelligent trial waiver consistent with state criminal procedures or Rule 11 of the Federal Rules of Criminal Procedure. But let's say you realize there is a problem after submitting a guilty plea, such as the prosecutor didn't seem trustworthy and you think they're bluffing about the evidence. You think the police officer is lying. The trial court judge may have done something wrong when taking your plea. These issues are a good reason to revisit your case with your lawyer. In the post-conviction case, filing a written motion is the first step to walking back your guilty or no contest plea. Describing your good cause claim. A motion to withdraw your guilty plea must include good cause and explain why the judge should allow you to change your mind. Below are elements that should be included for your good cause claims. 1. You should provide factual basis for the plea. This is a defendant's knowing admission of guilt to all elements of the criminal charges. 2. You should confirm that you, the defendant, understood the charges against you and other collateral consequences. This may also include potential sentencing ranges and enhancements. 3. You should establish whether or not you were informed of your constitutional rights, including the right to an impartial jury trial, right to counsel, right to confront and cross-examine witnesses, and so on. 4. You should confirm or deny that your plea as defendant was voluntary. This includes whether the plea entered was by the defendant's free will or whether threats or false promises induced it. False promises differ from a valid plea bargain. Sidebar, we'll stop here for 1 second. Remember when Hitler laid that record down bit by bit by bit? We just kind of covered everything here that Hitler made sure to get on the record. You're doing this voluntarily of your own free will. You have not been promised, coerced, or threatened. Blah, blah, blah. You have not been intimidated, right? Right? Isn't that interesting? AR, hey, it's so good to see you. So good to see you. Welcome on in, everyone. Good to didn't get moved because of being harassed. He got moved to bottom tier as he takes meds, and it's easier for the med nurse with everyone who takes numerous meds to be bottom tier. Gotcha. Thanks, AR. Appreciate you. Thank you so much. Okay. Let's get back over here. All right. So, filing a motion with the court. If you believe you meet the above test, file your motion with a district court clerk. Let's read that again. Remember, many state laws allow a defendant to withdraw the plea for sentencing. After sentencing, the criminal procedure timelines to file a motion tend to be very short, depending on whether you are in state or federal court. The deadline could be as little as 10 days after a sentence has been imposed to correct a manifest injustice. If you change your mind later, you can always withdraw the motion. When in doubt, it's often better to file rather than get barred forever. Petition of habeas corpus. A writ of habeas corpus may be your best option if you have missed the deadline to file or the judge denies your request to withdraw your plea. This is a petition claiming your imprisonment is unconstitutional. A writ of habeas corpus is often combined with ineffective assistance of counsel claims and filed in state or federal court. Habeas corpus is an additional avenue to challenge your imprisonment based on the following: 1. Wrongful conviction. 2. Illegal sentence. 3. Systematic errors. 4. New evidence. This is a last-ditch effort used after a direct appeal has failed. Every case is different. Consider consulting an appeals lawyer for legal advice. Appealing a conviction after a guilty plea. Defendants can file a direct criminal appeal of their conviction or sentence with a higher court, such as the state or federal court of appeals or the Supreme Court. If you are successful during the appeals process, the appellate court's decision can: 1. Set aside the judgment and discharge the petitioner. 2. Require resentencing the petitioner after a sentencing hearing. And 3. Grant a new trial or make other disposition as may be appropriate. Another avenue you can explore is filing a petition for post-conviction relief. This type of petition must be filed after a direct appeal. Additionally, it may not be based on the grounds that could have been raised on direct appeal of the conviction or sentence. It may not be based on grounds that could have been raised on direct appeal of the conviction or sentence. For example, let's say you pled guilty to hit and run, but no, you weren't driving the car. You just wanted to put all this behind you. Suppose you later discover that there's video evidence of the accident that shows the driver was actually your brother-in-law who took your car without your permission. In that instance, you can likely win your case. Okay. So, wanted to share that one with you guys just because it was quick, it's to the point. I think it gives a lot of information for anybody who has questions about what can be done, how it can be done, some of your avenues, right? Personally, I just think that, this kind of stuff I like to geek out on. So hopefully, you like geeking out on it too. The link for it is in the description of the video. And then let's go here. This one was the long one, but we don't have to look at all of it. I just wanted to go over it with you guys, make sure that's big enough. How's that? I think that's good. There we go. Are you very welcome, Danger? Anytime. Thanks for being here. So good to see you. Always good to see you. Beautifully broken woman. Well, I'm so sorry that you have been having health issues. I hope you are doing well. Has something new happened? I don't think so, no. I've just been getting a lot of questions about appeal, post-conviction relief. What do you think could be done? I mean, I personally don't know if they're going to do anything. I just figured maybe this will help um, for the people who've had questions, just to kind of look at it together. Yeah, that sheet. Yeah, I tend to agree with that. I feel like they were kind of hamstringed, but they couldn't get nothing through with Hitler. It is what it is. Literally couldn't get nothing through with him. So everything was denied. Didn't matter what it was. Frank's motions to suppress, motion to continue, alt perps, motions in limine. Know what I mean? I think there was very few things he actually like granted for them. And I think, in my opinion, that was just to like give the appearance that he's not biased when he's probably the most biased judge I think I've ever witnessed. I mean, we thought Bev was bad, right? We thought Bev was bad. Like, Hitler, I think, is worse than Bev, but that's just my opinion. Redacted meanie. I even heard a solid guilter say he doesn't think it's over yet in his live last night. That's pretty funny. That's actually wicked funny. I mean, it might not be. We have no idea, right? We have no idea what they're gonna do. We really don't. All right, so challenging unjust convictions under Section 1983. So now there are a few things just to have like some context. We'll read a couple of things, and then we don't have to read this whole thing. It's 29 pages. There was just a couple of things in here I felt maybe could pertain, but I'm no lawyer or nothing, so don't listen to me. This is not legal advice. Let's see. Challenging unjust convictions under Section 1983, Heck v. Humphrey and its progeny. Um, this is from Joseph Kushner, Distinguished Professor of Civil Liberties Law, Hofstra University School of Law. Professor Friedman is considered a leading scholar in the subjects of civil rights, civil procedure, criminal procedure, and the First Amendment. This article is based on a transcript of remarks from the Practicing Law Institute's 23rd Annual Section, 1983 Civil Rights Litigation Program in New York. 42 USC, 1983, looks like it was 2000, states in pertinent part, quote, every person who under color of any statute, ordinance, regulation, custom, or usage of any state subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. And the reason that I thought that that was pretty interesting, right? Because for every person who, under color of any statute, ordinance, regulation, custom, or usage of any state. So, if you are acting as an agent of the state and you subject or cause to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any of their rights, privileges, or immunities secured by the Constitution and laws, you shall be liable to the party you injured in an action at law, suit in equity, or other proper proceeding for redress. So it just kind of stuck out to me. If you get it, you get it, and if you don't, you don't. Here, in the example of Kohberger's case, we know that many people were acting as agents of the state to quite possibly cause to be subjected the defendant from his rights. He was deprived of his rights, especially, where they conceded the backdooring of the DNA. Hitler doesn't think it's a rights issue, but, well, the American people would beg to disagree, which is why they didn't want it ever getting out, because they know that the American public would have a huge problem with an agent of the state backdooring people's DNA because they believe they're above the law and they don't have to abide by it, and your rights don't matter. Right? Just saying. Just saying. Hitler even in his order on it says, even if. And if you've been here for a while, you know, when we get to reading Hitler's orders and you get down to the paragraph that starts off with, even if what the defendant claims is true, it's not a rights violation. It may have violated some terms of service. The FBI may have violated some DOJ policies. There may be some civil action, right? This might be a civil issue, but it's not a rights violation. Everybody remember that. Everybody remember that, right? I'm sure everyone remembers that. That's Hitler's famous words. Okay. Even if anything, even if what the defendant claims is true, that's how you know it's true. That's how you know it's actually true. Because he's like, well, even if your claim is true, I'm not going to allow it because, well, I don't think it's a rights problem. I don't think it's about your rights. It's just about policy. And so what if they violated policy? So what? So what if they violated policy? So what if they violated the terms of service of the DNA database that specifically, explicitly prohibits law enforcement from accessing their database? It's absolutely wild. So, literally, first little footnote here. I could sidebar for 10 minutes on, but I won't. Enough of my bullshit. Suzanne B., hello. How are you? If I'm missing anybody else, I'm so sorry. Ali Guido, hello. I haven't seen Bree Sully in forever. Bree, if you're on Replay Crew, what up, gangsta? And I don't know where my Mercy Cat is. I don't know where Mercy Cat and Elroy are. I hope they're on Replay Crew too. Or maybe just lurking in the background. Maybe my Mercy Cat is just lurking. I hope so. Love you, Mercy Cat. Okay, next one. What do we have here? Let's see, US 447, 1994, at 486, 487. Let's see, holding that to recover for an unjust conviction, a plaintiff must prove that his or her conviction or sentence was reversed in a direct appeal, invalidated by an authorized state tribunal, expunged by executive order, or, quote, called into question by a federal court's issuance of a writ of habeas corpus. So this is definitely also another avenue. So if you can get a federal court, right, to call into question the court's issuance of a writ of habeas corpus, right? You can appeal to a higher court. If you can get a federal court to give you that writ, right? So to me, there's like two things there, right? I personally feel like you could probably definitely go for a rights violation on the DNA, the backdooring of the databases. You could probably go for a rights violation, um, in my opinion, for the fact that, as far as I know, there was no federal court that ordered the FBI permission to place cameras on the private property of the Kohberger residence on Christmas Day, December 25th. I don't remember seeing, like, even in some of these doc drops that we've got where we see unclassified FBI documentation. Anybody see anything in there where there's a court order from a federal court? Like, yeah, go ahead. Sneak onto the private property and go plant some fucking cameras around it on Christmas Day. Where did they put them? Does anybody even know that? Where were these cameras placed? And this is 2 days before they take the trash. Does anybody even know? I don't know. I haven't seen anything. I haven't seen anything in any of this stuff about a federal court granting federal agents permission, or even out of Pennsylvania. I haven't seen anything out of Pennsylvania giving them permission to go into the private gated community and plant cameras on the private property of the Kohberger residence. I haven't seen it. And you already know there's going to be someone too. You know that that Jim guy is going to come into my comments telling me I don't know what the fuck I'm talking about or something. It's in the documents. Off the top of my head, I don't know which document it's in, but I distinctly remember there's a document from the defense. I believe Miss Masseth. It might be motion to suppress PA warrant or something like that. I remember correctly. It's like the motion to suppress the PA warrant or something. And she's going off in that document about how, like, the FBI, these federal agents, these collaborative, Pennsylvania State Police working with feds, and they're placing cameras on the private property of the Kohbergers on December 25th, which is wild. 2 days before they pulled the trash. And I haven't seen anywhere where there's a court order from a judge that they were allowed to do that. Not out of PA, not out of nothing from Meghan Marshall, right? They got their warrant allegedly for the trash pull. Or no, that's right. They never did a warrant for the trash pull because allegedly it was just on the curb. You abandoned it, right? It was abandoned. So anyways, it just always bothered me that there's been no explanation as to who granted the feds or anybody else permission to place hidden cameras on the private property of the Kohberger parents' home. Just wanted to point that out. So, I mean, there are a couple things maybe that you could get a federal court to, if you're going to try to get a writ of habeas corpus, I mean, I guess you could try and get a federal court to call into question a few of these things that have happened here. All right, so let's get down here. It does cite Heck v. Humphrey, which was decided in 1994, set the precedent for using 1983 to challenge unjust convictions. Approximately 1,930 decisions have cited to Heck in the past 12 years, which includes 140 circuit court decisions. I did not even count the district court decisions because such a task would be quite difficult given the unwieldy number of decisions. One may wonder why so many decisions cite to Heck. The reason, or part of it, is that a large portion of these cases are brought by prisoners. And prisoners, as we all know, often initiate complaints or litigation because they are unhappy about their imprisonment. The problem in a case like Heck, or other cases such as Prizer v. Rodriguez and Edwards v. Balasag, is that these decisions held that a prisoner cannot challenge a prison disciplinary actions if the result of the challenge may lead to a change in the term of imprisonment. These decisions held that a prisoner cannot challenge a prison's disciplinary actions if the result of the challenge may lead to a change in the term of imprisonment. Thus, because such actions are barred by Heck, the number of decisions citing to Heck tends to be quite high. The first important case in the Heck line of decisions is the Prizer decision, which held that a prisoner convicted of a crime simply cannot challenge the conviction in a 1983 action, or Section 1983 action. The prisoner's only basis for a challenge was habeas corpus. The Prizer court explained that a prisoner cannot challenge his conviction or sentence in a Section 1983 suit because any challenge would assume that there was something wrong with the conviction or sentence, which must remain unchallenged because a subsequent challenge is barred by res judicata. A prisoner cannot challenge the conviction or sentence because, based on res judicata, a court already decided he was guilty and that decision is on the books. Judicata, however you say it. Res judicata. Now I want Google to tell me how to say it right. I'm not a lawyer, so I don't have to pronounce it right. Hence, because there is a final judgment and sentence, a prisoner cannot bring a subsequent suit that challenges the judgment in the first action. Therefore, the unjust conviction analysis begins with Prizer, which seems to be a plausible decision. Heck v. Humphrey. In Heck, however, unlike Prizer, the plaintiffs merely sought damages and were not trying to upset their convictions. In other words, the decision's result would not release the plaintiffs from jail. Instead, the result of the case would give the plaintiffs money based upon the claim that the conviction was improper. The court held that a plaintiff could ordinarily file a Section 1983 action for damages without having to exhaust all state remedies. Let's go up here and read this footnote real quick. The court held when a state prisoner is challenging the very fact or duration of his physical imprisonment, and the relief he seeks is a determination that he is entitled to immediate release or a speedier release from that imprisonment, a remedy is a writ of habeas corpus. The court explained that while res judicata principles are not entirely applicable to a habeas corpus proceeding, they are applicable to a Section 1983 action. Furthermore, that if res judicata did not apply to Section 1983 actions, quote, there would be an inevitable incentive for a state prisoner to proceed at once in federal court by way of civil rights action, lest he lose his right to do so. This would have the unfortunate dual effect of denying the state prison administration and the state courts the opportunity to correct the error committed in the state's own prisoners, and of isolating those bodies from an understanding of and hospitality to the federal claim of state prisoners in situations such as those before us. The court explained that exhaustion is generally a prerequisite for a federal habeas corpus action, and it is not a prerequisite in a Section 1983 suit. The court discussed the common law of torts of malicious prosecution and false arrest, finding that the principle that, quote, civil tort actions are not the appropriate vehicles to challenge the validity of outstanding criminal judgments, end quote, should apply to Section 1983 suits, which require the plaintiff to prove the unlawfulness of his conviction or confinement. Okay, there was something else I wanted to read to you guys because I thought it was pretty interesting. Where was it? Get back up here. I just wanted to read those footnotes to you. Okay. The court held that a plaintiff could ordinarily file a Section 1983 action for damages without having to exhaust all state remedies. Yet, a Section 1983 action that challenges the legality of an underlying conviction cannot be asserted, quote, unless and until the conviction or sentence is reversed, expunged, invalidated, or impunged Impugned, Annie. Impugned, dipshit. Quote, unless and until the conviction or sentence is reversed, expunged, invalidated, or impugned by the grant of a writ of habeas corpus. Therefore, a prisoner cannot file a Section 1983 claim for damages that challenges the validity of the conviction or imprisonment because any assertion that the arrest was improper, as is required in common law tort actions for false arrest or conviction, necessarily encompasses a challenge to the conviction itself. Again, while it has nothing to do with exhaustion, it is merely that the prisoner has a predicate to his or her Section 1983 action that is barred by res judicata, namely the judgment of conviction. Come back to chat. Everybody following along, hope you're having a great night. Thank you for being here. Wanted to come back to chat, say hello. Oh my goodness, California Kane, hello. Did you have so much fun last night with Outcast? That was you, right? Same person, right? On Outcast last night for trivia? Halls, hello, honey. So good to see you. Welcome on in, everybody. Beach Babe, did I already say hi to you? Legalese, yeah. It's also because I don't have my glasses on, Meg. I know. Not only do I not have my glasses on, I'm looking at some of right, and Meg knows me, so if you're new here, when I don't know how to pronounce the word or I'm not sure, I will usually go to Google. I have to look up the definition. I have to have Google tell me how to pronounce it because I don't want to sit here. I'm not a lawyer, though, right? I'm not a lawyer. So I'm not supposed to get some of this stuff right. And I shouldn't be. So that's how I look at it. It's okay if I pronounce some of these words wrong. I'm not a damn lawyer or a judge. I just like to nerd out. Ali Guido. Good stuff. Thanks, honey. Yes, okay, California Kane. He was calling you cocaine. And I was dying laughing. He was calling you cocaine all night. Detective Mowry, you sandbagging son of a bitch. So good to see you. Welcome on in. Also, a Manel claim can raise a conjunction to a 1983 claim, but it's super high burden on a plaintiff. Yes, yes. Good to see you, Detective Mowry. Always good to see you. I thought you guys swept it, though. Kane, I thought you swept it. I could have sworn you guys took it at the end, though. I mean, it's fine. We didn't win anything. We just got to have fun. Mama J, what about all the untested DNA? Wouldn't they have to still test and turn over any results that Anne asked them to do, regardless of Brian taking the plea? Can Bill just cancel the lab tests like he did? Well, I mean, it's my understanding that even if the defense wanted to have all of that DNA tested, you mean now? You mean now that it's all closed out or whatever? I don't know how they would go about getting access to those profiles, being able to obtain the profiles. We know that the lab reports state that even though some of these samples, they consumed the entirety of the sample, a profile was still retained with the lab. Whether or not those profiles have already been dispositioned, destroyed, whatever you want to call it, right? I guess I have no idea. I have no idea whether or not those things are even still there. If they even have the ability to acquire them. I have no idea, honey. But excellent question. All right, so let's see. Go back over here. Let me go back to this other window. There was something else. This was one of the things that made me laugh, kind of. It just made me giggle when I was reading through some of this stuff. Because I was like, well, I could have sworn he was complaining about his food and stuff, right? The action that a prisoner brings to attack a prison procedure assumes the invalidity of some judicial type proceeding, which has not been undermined prior to the prisoner bringing the instant suit. Thus, the holding in Edwards is similar to exhaustion cases under the Prison Litigation Reform Act. There is some predicate barring a prisoner from bringing a case some element in the claim that a prisoner cannot challenge. Then you also have Wilkinson v. Dotson. Is this the one that was about the food? Hang on. Oh, here we go. Okay. So one of these footnotes here is for this Balasag, right? Which one of the things that was cited back in the beginning. It's like some of the cases that have to do with Section 1983, right? The precedent. We have this Balasag one, right? In the footnote here. It says, in Balasag, the prisoner claimed that, quote, he was completely denied the opportunity to put a defense on through specifically identified witnesses who possessed exculpatory evidence. My brain was immediately like, alt perps, alt perp brainworm, alt perp brainworm. That's immediately what I thought. I was like, well, yeah, yeah, the prisoner claimed, quote, he was completely denied the opportunity to put a defense on through specifically identified witnesses who possessed exculpatory evidence. That's Bethany. That's your alt perps, right? There's two right there. I just think, I nerd out on it. I'm not saying that that they could do this or cite these cases or use Section 1983. I have no idea, right? I'm just saying that isn't it interesting in Balasag, the prisoner claimed that, quote, he was completely denied the opportunity to put a defense on through specifically identified witnesses who possessed exculpatory evidence. Well, that would be Bethany and your four alt perps, because the state was using the four alt perps as witnesses in their case in chief, right? And in my opinion, Hitler not allowing the alt perp defense to come in violated the due process rights of the defendant, because the defendant has the right to confront the witnesses and the evidence, especially when those witnesses happen to be the defense's four alt perps that the state is trying to use in their case in chief. If you want to use these four alt perps as your witnesses, then you opened the door. But I don't know shit. I'm just saying, I don't know anything. Custody queens will probably be able to either, no, Annie, you're wrong. And that's great. Okay. If they come back and say, no, bitch, you're wrong, I'm cool with that. I don't mind being wrong. But pretty interesting. Pretty interesting. There's one about the food, though, and it just made me giggle. Let's see. Then there's the Prison Litigation Reform Act, citing Poe v. Ennis. A prisoner's administrative remedies are deemed exhausted when a valid grievance has been filed and the state's time for responding thereto has expired. What's this other one? Wright v. Hollingsworth holding that the PLRA required defendant to exhaust all available remedies prior to initiating a federal action. Okay. Court explained that the prisoners in Wilkinson's were not seeking to secure an earlier release from prison or a change in their status. Instead, quote, success for Dotson means at most new eligibility review, which at most will speed consideration of a new parole application. Success for Johnson means at most new parole hearing. Okay, so that doesn't apply. There's something in here about the food. I'm telling you guys, once I read it, we'll read it. I was kind of laughing. Hill v. McDonough. Last year, the Supreme Court added to the previously discussed rulings in the case of Hill v. McDonough. In the Hill case, a death penalty decision, a prisoner challenged the specific method used to lethally inject prisoners. The court explained that the prisoner was not challenging the death penalty because the complaint only sought to force the respondents to find some other method to execute Hill. Therefore, the action was viewed as a challenge to the three-drug protocol to bring about the lethal injection and not the lethal injection itself. Hill built a case from the previous year, Nelson v. Campbell, where the challenge was to the method of accessing the vein of the individual. Yet Nelson and Hill simply challenged the method used to administer the death penalty. Therefore, the court held that the challenges in both cases did not create a health problem. And then we got footnotes here about the 3-drug protocol, uh, injunction, blah, blah, blah. Let's go down here. Maybe it was this one. Peralta v. Vasquez, a recent case decided by the Second Circuit, took the analysis one step further. Peralta involved a prisoner's challenge to a prison disciplinary proceeding, but part of the challenge would have changed the prisoner's status because it would have taken away good time credits. Yet the challenge brought by the prisoner only generally challenged prison procedures. The prisoner argued that it was a bad procedure that led to the termination of his good time credits. The question became, if there are two sanctions in a case, one that affected the duration of the custody and the other that affected the conditions of the confinement, can a prisoner maintain the challenges? The Second Circuit, in a decision by Judge Calabrese, held, quote, in mixed sanction cases, a prisoner can, without demonstrating that he challenged disciplinary proceedings, have been invalidated, proceed separately with a Section 1983 action aimed at the sanctions or procedures that affected the conditions of his confinement. In mixed sanction cases, a prisoner can, without demonstrating that he challenged that the challenged disciplinary proceedings have been invalidated, proceed separately with a Section 1983 action aimed at the sanctions or procedures that affected the conditions of his confinement. Suppose a prisoner asserts the following quote, I am not altering, I am not asking for a change in my good time credits. I just want the procedures that were followed to be changed. According to the Second Circuit, a prisoner can challenge the procedures used and can bring an action if he agrees to abandon forever any claims he has with respect to the sanctions that affected the length of his imprisonment. Essentially, it is not enough for a prisoner to say, quote, okay, I am not going to challenge the length of my imprisonment. I will do that in the future after I made some internal administrative change, end quote. The Second Circuit held that a prisoner must, quote, abandon any claims he may have with respect to the duration of his confinement that arise out of the proceeding he is attacking in his current 1983 suit. Thus, the Second Court found a prisoner must give up his claim because the court does not want to have to hear a prisoner's claims piecemealed through multiple lawsuits. The court therefore decided to make a distinction between a challenge that affects the length of your internment and a suit that simply challenges a procedure that led to the imprisonment without in any way affecting the result. While this case is somewhat strange, the court's rationale seems to be that it does not want a bifurcated case. In conclusion, Heck and its progeny are very important because they close the door on Section 1983 cases. Even if you think something about your conviction is unfair, you cannot use Section 1983 to challenge the unjust conviction, but must use habeas corpus instead. Habeas corpus, however, is particularly difficult because the Anti-Terrorism and Effective Death Penalty Act has numerous requirements, such as exhaustion and a very short statute of limitations, which essentially prohibits a prisoner from initiating a lawsuit immediately after conviction. Let's read that again. Habeas corpus, however, is particularly difficult because the Anti-Terrorism and Effective Death Penalty Act has numerous requirements, such as exhaustion and a very short statute of limitations, which essentially prohibits a prisoner from initiating a lawsuit immediately after conviction. Additionally, there is deference to state fact-finding and state legal conclusions. Further, under the AEDPA, the plaintiff must show that there was an unreasonable application of the law. The AEDPA's numerous provisions make it very difficult for a prisoner to challenge his or her conviction. Naturally, a prisoner wants to go straight into court after being convicted so that he or she can remedy the circumstances. Yet, the AEDPA prohibits such action. Instead, a prisoner must go through the state post conviction, exhaust everything, and face all the difficulties of AEDPA, which is one of the reasons why prisoners come into federal court with a Section 1983 lawsuit. In turn, the federal courts dismiss such actions, and this is why Hack has been cited 1,930 times. Isn't that wild? Isn't that insane? So, like, what they're saying here is even if, right? The whole point of the live is can Brian appeal? Well, even if he's going to, according to this, right, the AEDPA prohibits such action as far as like immediately being able to, challenge your conviction immediately after going to jail, right? The AEDPA's numerous provisions make it very difficult for a prisoner to challenge his or her conviction. Naturally, a prisoner wants to go straight into court after being convicted so that he or she can remedy the circumstances, yet the AEDPA prohibits such action. Instead, the prisoner must go through the state post conviction, exhaust everything, and face all of the difficulties of the AEDPA, which is one of the reasons why prisoners come into federal court with a Section 1983 lawsuit. And in turn, the federal courts dismiss such actions. So he's going to have to, like, even with habeas corpus, it's a very, very short, right? Isn't that what we just read up here? Like, right here. Habeas corpus, however, is particularly difficult because the Anti Terrorism and Effective Death Penalty Act has numerous requirements, such as exhaustion and a very short statute of limitations. I don't know what that is. I can look it up. I don't know what the habeas corpus is in Idaho. I'm not sure. Federal court, Idaho court, I have no idea, but just wanted to put that out there. It's saying here that actually you have a very short statute of limitations on that. And because of this AEDPA, it has numerous requirements. You have to exhaust everything else first, right? Back over to chat. Sorry. Let me see. Miss Q. Miss Potts, can you go back to the prosecution fact-finding part? Let me see. Where was that? Let me go find that. Probably appear fact-finding. Don't have my glasses on, so hang on. I'll find it, don't worry. Fucking A, I don't see it, honey. It's probably right in front of my eyeballs. They're kind of burning out of my head right now, though. The court therefore decided to make a distinction between a challenge that affects the length of your internment and a suit that simply challenges the procedure that led to the imprisonment without in any way affecting that result. While the case is somewhat strange, blah, 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 in conclusion, Heck and its progeny, blah, blah, blah. Even if you think something about your conviction is unfair, you cannot use Section 1983 to challenge the unjust conviction, but must use habeas corpus instead. I don't know where it went, honey. Right here. Additionally, there is deference to state fact finding and state legal conclusions. Footnote 34. Let's see what that is. Imposing a burden on the applicant to rebut the presumption of the correctness by clear and convincing evidence. That's all it says. Let's see. Section 1983 liability for alleged violations of the detainee's rights can be premised on two theories. One, that the conditions of the confinement violated the detainee's rights, or two, that the episodic acts or omissions of officials violated those rights. That's all it says, honey. All right, here we go. It might be this one. Challenging unjust arrest, excessive force searches, conditions of confinement. Yeah, right here. Right here. There are some cases where a person can bring a Section 1983 action, such as when a prisoner challenges the conditions of confinement. Prisoners can bring a challenge to certain conditions, such as receiving improper medical treatment or inadequate meals. It made me giggle. Don't ask me why, it just did. Let me see. Yeah. Prisoners can bring a challenge to certain conditions, such as receiving improper medical treatment or inadequate meals, whatever aspect of confinement the prisoners dislike. Yet, the PLRA creates an enormous number of hoops a prisoner must jump eh, through and over to bring a suit. Under the PLRA, a prisoner must, among other things, exhaust all administrative remedies. Again, there are a whole series of procedures a prisoner must follow, making it difficult to bring a suit, but heck does not preclude the prisoner's PLRA lawsuit. Numerous cases deal with the conditions of arrest. When a person is arrested, can the prisoner bring false arrest claim while he or she is incarcerated and awaiting trial? Courts have held that the answer is no. Such action is clearly barred because if a person is falsely arrested due to a lack of probable cause, the issue cannot be addressed until a jury renders a guilty verdict. Let's go read the footnote. Let's read this one first. Footnote 39. Numerous cases deal with the conditions of arrest. Footnote 39. Boyd v. City of New York, finding a former prisoner's Section 1983 action for false arrest and false imprisonment should be denied, but remanding the prisoner's malicious prosecution claim. Wallace v. City of Chicago, Seventh Circuit Court, denying the plaintiff's Section 1983 action for false arrest due to statute of limitations. We have another one, Chachery necessarily stemming from. Okay, let's read footnote 40, right? Courts have held that when the answer is no, such action is clearly barred because if a person is falsely arrested due to a lack of probable cause, the issue cannot be addressed until a jury renders a guilty verdict. Footnote 40. Covington v. New York City, holding that false arrest claims accrue at the time of arrest. But if the Section 1983 lawsuit's success would imply the conviction's invalidity, it does not accrue if the potential for a verdict in the underlying criminal prosecution exists. Hamilton v. Lyons, finding that heck prevents the accrual of Section 1983 claims that would imply the invalidity of convictions on pending criminal charges. So you can't even try to say, hey, I was falsely arrested while you're awaiting trial. You can't even try to argue that according to this here. You have to wait until the jury has rendered a guilty verdict. right? If I'm not reading that right, then please let me know. But courts have held that the answer is no. Such action is clearly barred because if a person is falsely arrested due to a lack of probable cause, the issue cannot be addressed until a jury renders a guilty verdict. Arguably, one has nothing to do with the other. Logically, that is true, but courts do not look at it that way. And then it goes into excessive force, all of that. I feel like there was something else in here I wanted to look at. That's also excessive force. Statute of limitations problems. The big issue in a Section 1983 challenge by prisoners is when does the statute of limitations begin to run? Many cases discuss this issue in the context of the respective Section 1983 challenge at issue, such as challenges to a false arrest, excessive force, and malicious prosecution. That's the one that I feel like they might be able to roll with too, malicious prosecution. It's a footnote here. Seventh Circuit stating that an inmate could challenge the lawfulness of a search even if it revealed evidence that was used to convict. Oh, okay. Let's see. Statute of limitations arose in Wallace v. City of Chicago when a prisoner brought a Section 1983 action for damages arising from false arrest. Wallace presented the following problem. Andre Wallace was arrested, put in jail, and convicted of murder. After the conviction, Wallace asserted that his original arrest was unconstitutional and subsequently the conviction was overturned. Thus, any heck problems that might have existed before the conviction was overturned disappeared. Next, Wallace filed a Section 1983 action for damages arising from his false arrest. The dilemma was, however, that it had been 6 years since the arrest and 5 years since the conviction. The district court granted summary judgment against Wallace, holding that his false arrest claim was barred by the statute of limitations, which was affirmed by the Seventh Circuit Court of Appeals. Footnote 55. What the hell is that? Probably right in front of my face. Oh, okay, it's just that. Okay. Interesting. District court granted summary judgment against Wallace, holding that his false arrest claim was barred by the statute of limitations. So, I mean, that's just another thing to think about, guys, right? Statute of limitations here. All right, so Wallace requested a rehearing in Bain, which the full circuit court denied through Judge Posner, though Judge Posner wrote a brilliant dissent. The Wallace case illustrates the current problem many individuals endure. When does the claim accrue with respect to excessive force or false arrest? Malicious prosecution is easier to establish because an element of malicious prosecution provides that a convicted defendant's claim only starts to run when the conviction has been overturned. But what about false arrest? It is perfectly plausible to say, as Judge Posner did in his dissent in the Wallace case, that a plaintiff could avoid dismissal by utilizing the doctrine of equitable tolling, which allows, quote, a plaintiff to delay suing beyond the statutory limitations period if he is unable, despite all due diligence, to sue within the period. But as soon as he is able to sue, he must. Yet, under Heck, you could not bring the false arrest case. Hence, the dilemma is as follows. Court, hey, wait a minute. You should have brought your claim a year after your arrest. Plaintiff, I could not bring a suit a year after my arrest because, under Heck, I was precluded from doing so. Court, well, it is too bad. Your statute of limitations has run out. The Supreme Court has now affirmed the Seventh Circuit decision, holding that false arrest claims accrue at the time of arrest. Isn't that wild? I mean, I don't know, guys. I don't know if this is interesting to you, but it was interesting to me. Okay. It was interesting to me. I nerded out. It is what it is. Hopefully you don't mind nerding out with me. Doc Terry, oh my goodness. Hello, so good to see you. So good to see you. Welcome on in. Welcome, welcome. Well, that's what I'm saying, Leslie and Billy. I have no idea. I'm not sure what the statute of limitations is for this, like in Idaho or whatever, or for him specifically. I just found this. I geeked out on it earlier and I thought, well, there's some interesting stuff in here that I wanted to share. And, exactly, yeah, redacted meaning, right? It is kind of a BS decision, yeah. But you know what? The Supreme Court affirmed it. The Supreme Court affirmed it. Oh, well, thanks, Danger. Thank you. Sometimes you read something and you're like, oh, wait, actually, that kind of applies. Is this list pretty much exhaustive? M. Kane Ultra, welcome on in. Good to see you. Always good to see you. Welcome, welcome. This goes into excessive force, which I don't think excessive force was used, at least not on Brian. I have talked about Bivens before, the Bivens doctrine. If you missed that live, it's in there somewhere in the playlist. I did do a live on like the Bivens doctrine before. I feel like technically Brian's parents could probably, if they wanted to, sue under Bivens, but actually their statute of limitations might be up on that now. It's been 3 years. Wait, so if we just read here that the Supreme Court has affirmed, hang on, false false arrest claims accrue at the time of arrest. So, hmm. So his statute of limitations might be up on that. It's been 3 years. It starts accruing at the time of your arrest, right? Interesting. All right, so that's the excessive force thingy. I don't think we have to look at that. I feel like there was something. Oh, here it was. Yeah. Malicious prosecution. All right. Professor Friedman here says, suppose an individual is convicted of a crime and the conviction is reversed. After the conviction is reversed, the individual begins suing everyone in sight because of his unfair conviction. Who is everyone in sight? You would want to sue the officers who arrested you, as well as the prosecutor who brought the grand jury indictment and prosecuted the case that led to your conviction. Thus, one should sue the prosecutor for malicious prosecution as well. First, you must prove malicious prosecution, which is a 4-part test under common law. Footnote 71. C. Martinez v. City of Schenectady. Probably didn't say that right, New York. Under common law, malicious prosecution requires that the plaintiff establish 1. That a criminal proceeding was commenced. 2. That the criminal proceeding terminated in favor of the accused. 3. That the proceeding lacked probable cause. And 4. That the proceeding was brought out of actual malice. If you establish a constitutional malicious prosecution, you will prevail. It's footnote 72. Yeah, right here. If you establish a constitutional malicious prosecution, you will prevail. That's footnote 72. See Roman v. New York City Transit Authority, stating that in addition to the four New York common law elements of malicious prosecution, a plaintiff alleging constitutional malicious prosecution under Section 1983 must assert a quote sufficient post arraignment liberty restraint to implicate the plaintiff's Fourth Amendment rights were violated. Therefore, a plaintiff asserting a malicious prosecution claim under Section 1983 must show a denial of liberty consistent with the notion of a seizure. If you don't prevail, heck applies and you cannot prevail. So if you can't win on malicious prosecution, then heck applies and you're fucked. You can't prevail. Sorry. If an individual can establish the elements of constitutional malicious prosecution, he will want to sue every person who put him in jail, including the police officers and the prosecutor, since he was wrongly incarcerated. There may, however, be a problem in suing the prosecutor because absolute immunity may apply. Footnote 73. A prosecutor is absolutely immune from a malicious prosecution action, the decision to prosecute the case. Hartman v. Moore. Then, let's see, citing Imbler v. Pachtman. However, a prosecutor may still be liable for any, quote, conduct taken in an investigatory role or the offering of legal advice to police regarding interrogations. So in Imbler v. Pachtman here, no, sorry, Buckley v. Fitzsimmons, sorry, citing Buckley v. Fitzsimmons, it says, however, a prosecutor may still be liable for any, quote, conduct taken in an investigatory role. Well, we know they did that with the DNA. It was the prosecutor making all the calls with that stuff, right? Conduct taken in an investigatory role, ignoring other male DNA, not identifying it. Maybe you know they're going to backdoor the DNA, right? Things like that. Did you advise it? Just saying, just questions. Okay. All right. So there may, however, be a problem in suing the prosecutor because absolute immunity may apply. Therefore, if absolute immunity applies, you can only sue the police officers. The requirements for common law malicious prosecution are 1. There was initiation of a criminal prosecution. 2. It terminated in the plaintiff's favor. 3. There was no probable cause. And 4. There was actual malice in the defendant's actions. If the officer can prove that he or she had probable cause, then the officer cannot be held liable for malicious prosecution. That's footnote 75. Gismondi v. Town of Harrison, stating that a plaintiff may not prevail against the officers on a malicious prosecution action if the police had probable cause to suspect the plaintiff committed the alleged crime in the first place. Also, liability cannot be imposed on an officer in a malicious prosecution action if the prosecutor made an independent judgment to continue with the charges. The prosecutor made an independent judgment to continue with the charges. So liability cannot be imposed on the officer in a malicious prosecution action if it's the prosecutor who made the independent judgment to continue with the charges. So, you can't sue Payne if Bill independently decided he's still going to go ahead with the charges. And you can't sue Bill because Bill probably has absolute immunity. Just saying, right? Interesting. Isn't it funny how they all make sure that they just cover their asses from every angle? They can get people thrown in jail, convicted, tossed away, maliciously do it. possibly in violation of that person's rights, right? And, well, they're immune. They're immune in one way or another. Okay. Liability cannot be imposed on an officer in a malicious prosecution action if the prosecutor made an independent judgment to continue with the charges. And then it goes into New York terms of common law malicious prosecution. There is a law that provides if the grand jury indicts, the indictment creates a presumption of probable cause. This is a presumption that can be overcome. Footnote 78. The court explained that the presumption of probable cause may be overcome by, quote, establishing that the police witnesses have not made a complete and full statement of facts either to the grand jury or the district attorney, that they have misrepresented or falsified evidence, and that they have withheld evidence or otherwise acted in bad faith. Ooh, might have one there. Court explained that the presumption of probable cause may be overcome. So if if the grand jury indictment, right? If you because a grand jury will indict a ham sandwich. But if you can use that indictment to say, well, we established probable cause because see, we got this indictment. Well, the way to overcome that, according to the court explained the presumption of probable cause may be overcome by, quote, establishing that the police witnesses have not made a complete and full statement of facts to either the grand jury or to the district attorney, that they have misrepresented or falsified evidence, or that they have withheld evidence or otherwise acted in bad faith. Let's go one by one here. Police witnesses have not made a complete and full statement of facts either to the grand jury or to the district attorney. Well, I'm going to say grand jury. Anybody remember? Wasn't it after Dylan testified to the grand jury had a lot more questions about certain things, if I remember correctly? Yes? They have misrepresented or falsified evidence. Hmm. Hmm. Could probably roll with that one. Misrepresented or falsified evidence, or that they have withheld evidence or otherwise acted in bad faith. Well, your witnesses, Bethany and Dylan, one of them has exculpatory evidence, right? Ran away, didn't want to talk to anybody. I'd say that's acting in bad faith. She was worried about being arrested. She came back. Okay, let's see. Back up here. The indictment creates a presumption of probable cause. Okay, that's where we were. This is a presumption that can be overcome. For instance, the Second Circuit in McClellan v. Smith held that, quote, a grand jury indictment gives rise to a presumption that probable cause existed and therefore invalidates a malicious prosecution claim. Another way of overcoming the presumption is by bringing in a Brady violation, where one could argue that the prosecutor destroyed exculpatory evidence or the prosecutor failed to present the exculpatory evidence. Mm. In addition to the four elements of common law malicious prosecution, suppose the prosecution was terminated by an adjournment in contemplation of dismissal, ACD. Let me go read that, footnote 3, 83. I don't know what that is. Is that a termination in his favor? Unfortunately, the answer is no. Is it a termination for administrative reasons or something? It is not. There either has to be an acquittal, a reversal of the conviction, or the indictment has to be dismissed. But in simply dismissing it, an adjournment in contemplation of dismissal is not termination in favor of the defendant. Lack of probable cause and some kind of actual malice is a necessary prerequisite. Footnote 84. C. Martinez. Okay. For constitutional malicious prosecution, a plaintiff must show something more, a loss of liberty. footnote 85. See supernote 72, okay? If nothing bad happened as a result of the prosecution, the individual is arrested, released on his own recognizance, and the prosecution begins. Where is the constitutional violation? A loss of liberty is a necessary prerequisite. There must be a Fourth Amendment or Fifth Amendment violation. Thus, to bring a Section 1983 malicious prosecution claim, a plaintiff must have suffered a deprivation of liberty. Let's read footnote 86 here. U.S. Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Footnote 87. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment, indictment of a grand jury, except in cases arising in the land of naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so let's see. Excessive search, res judicata problems. Suppose you challenge, I guess we're reading the whole thing, friends, fuck it. Suppose you challenge an excessive search and a magistrate judge or court finds that there was probable cause. Although the parties are not the same, res judicata problems may arise because in the conviction, you were a defendant being prosecuted by the state, whereas in your suit against the officer, you are a plaintiff and the officer is the defendant. While there are some claims, while there are some claim preclusion and collateral estoppel problems that occur, ultimately res judicata problems are at the core of the suit. You always have to question what it was the court decided that is still on the books and has not been undone. Professor Schwartz. Here we are dealing with the state criminal proceedings, so there are potential preclusion problems, abstention problems, and potentially some Rooker-Feldman problems. Let's go read these footnotes. Res judicata is an issue that has been definitively settled by judicial decision. Okay. Issue that has been definitively settled by judicial decision. Or an affirmative defense barring the same parties from litigating a second lawsuit on the same claim, or any other claim arising from the same transaction or series of transactions, and that could have been but was not raised on the first suit. Black's Law Dictionary. Okay, well, there it is. Collateral estoppel is defined as, quote, an affirmative defense barring a party from relitigating an issue determined against that party in an earlier action, even if the second action differs significantly from the first one. Black's Law again. Rooker v. Patel. Oh, okay. Rooker. Here we go. In Rooker, the plaintiff sought to have the judgment of an Indiana Circuit Court, quote, declared null and void. The court stated, quote, if the constitutional questions stated in the bill actually arose in the cause, it was the province and duty of the state courts to decide them, and their decision, whether right or wrong, was an exercise of the jurisdiction. If the decision was wrong, that did not make the judgment void, but merely left it open to reversal or modification in an appropriate and timely appellate proceeding. Unless and until so reversed or modified, it would be an effective and conclusive adjudication. In Feldman, the Supreme Court had to determine what authority the United States District Court for the District Court of Columbia, and the United States Court of Appeals for the District of Columbia Circuit have to review decisions of the District of Columbia Court of Appeals in bar admission matters. The Supreme Court held that a district court cannot review a final decision of the highest court in that jurisdiction. Okay, got it. Okay. Supreme Court held a district court cannot review a final decision of the highest court in that jurisdiction. That's Isn't that obvious? I feel like that would be obvious, but I don't know shit. Okay. Here we are dealing with state criminal proceeding, blah, blah, blah. Rooker-Feldman, we read that. Rooker-Feldman. Here we go. The heck problem, however, seems to be the biggest problem of them all. It could be an insurmountable problem because, as you said, it's not an exhaustion rule. It's a rule that really becomes an element of the plaintiff's claim. If the claim comes within heck, the plaintiff's claim is not cognizable until the conviction is overturned, someplace and somehow. It could be overturned in a habeas proceeding, but it could also be overturned on appeal in a state court where the person could receive clemency. And then it has Brady claims under Section 1983. We all know about Brady. We don't need to go into that. Grand jury indicted you. You were convicted. Your conviction. Here we go. Yaris v. County of Delaware. Suppose you file a Section 1983 action because the grand jury indicted you. You were convicted, and your conviction was overturned because the prosecutor or the police destroyed exculpatory evidence. There is a recent case discussing this issue called Yaris v. County of Delaware. Yaris involved the deliberate destruction of exculpatory evidence. Deliberately destroying exculpatory evidence is not covered by absolute prosecutorial immunity. Prosecutors are immune for bringing the indictment, presenting evidence in court, and a few other actions. Destroying evidence, however, before it gets to court is not covered by any of the elements of prosecutorial immunity. The Yaris case is a very good opinion because the court found that even though the prosecution did not destroy the evidence, it knowingly withheld the evidence. The Third Circuit explained that withholding information, just like destroying information, is a Brady violation, and such conduct is not covered by absolute immunity. So let's go read the footnotes here. After serving 22 years on death row, Nicholas Yaris's conviction was overturned after he was given access to exculpatory evidence, which he claimed the Delaware County prosecutors and detectives purposefully obscured and destroyed evidence in an attempt to frame him for the rape and murder of the victim, Linda May. And then let's see, stating the courts apply a two-step inquiry, finding one, whether the facts alleged show that the defendant's conduct violated constitutional or statutory right, and two, whether the violated or constitutional or statutory right was clearly established at the time the violation occurred. This one, stating that prosecutors are not afforded immunity from a lawsuit arising from the prosecutor's alleged destruction of exculpatory evidence, since this action is not related to the prosecutor's prosecutorial function. Another one here, stating that since the prosecutors did not show that their denial of Yaris's DNA test requests occurred during an ongoing adversarial proceeding, or for the initiation of a prosecution, or for judicial proceedings, the prosecutors will not be entitled to absolute immunity, quoting Buckley v. Fitzsimmons. A decision was rendered in the Turner case approximately 6 weeks after the speech was delivered, blah, blah, blah. The Daniels Court held the Due Process Clause of the 14th Amendment is simply not implicated by a negligent act of an official causing unintended loss or injury to the life, liberty, or property. Okay, let's go down here, get to the gist. One could ask, could it be that in a criminal prosecution or habeas proceeding, a Brady violation could be based upon negligence, but in a Section 1983 case, the Brady violation would have to show more than negligence? That somehow seems illogical. But if the Supreme Court holds in 1983 context that a due process claim cannot be based upon negligent conduct, how does one square this? Well, there are a lot of Brady cases where the court says the prosecutor, even though he did not know exculpatory evidence existed, should have known that there was something pointing in the direction of exculpatory evidence. Like Bethany saying she's hearing fireworks and seeing sparklers under her door, Bill. The minute you get to that point, it becomes more than negligence, which is what most of these Brady Section 1983 actions discuss. The easy cases are when the evidence is there, but the prosecutor destroys or knows about it and does not do anything. Such actions, without a doubt, are both a basis for a Brady violation and a basis for a later Section 1983 action, and there is no immunity under those circumstances. Aside from Section 1983 action, there are other problems that may arise, such as the statute of limitations and absolute immunity problems. Eventually, you could bring an action into the Court of Claims under a New York statute, Court of Claims Act, Section B, blah, blah, blah. This is for New York, so we don't really have to get too far into that. He's in Idaho. With the Court of Claims action, a plaintiff must show that, quote, he has been convicted of one or more felonies or misdemeanors against the state and subsequently sentenced to a term of imprisonment and has served all or any part of the sentence. Therefore, the claimant must provide documentary evidence in order to prove the claim. Second, the claimant must show the judgment of conviction was reversed or vacated and the accusatory instrument dismissed, or if a new trial was ordered, either he was found not guilty at the new trial or he was not retried and the accusatory instrument was dismissed. Finally, you must prove the indictment was dismissed on particular grounds, including paragraph blah, 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 blah. Hence the state of New York statute, blah, blah, blah. We don't need that. We're almost done. There's only one page left. Why should there be a difference? If your conviction was reversed and indictment dismissed, why should it matter if it was a federal constitutional claim or state constitutional claim? The state of New York, in its infinite wisdom, has said it is not interested in giving relief to defendants whose claims were dismissed on federal constitution claims. Therefore, in my case, I had to argue that the Brady claim is fraud within the meaning of one of the subsections of New York's criminal procedural law. A case from the Appellate Division, Second Department, supported the claim. Currently, I am writing for the Court of Claims to render its decision. And that's it. That's it, friends. We actually did the whole 29 pages. Did my audio actually hold up the whole time or no? All right, I'm back in chat, back in chat. Did my audio hold up? Hopefully nothing was clipping out. We weren't clipping out. I don't know. I have no idea. So sorry if I was. I got real deep into that. Moonlit baby. Hello, good to see you. Welcome on in. Yes, danger. Danger. There are 1,000 red flags, 10,000 red flags. You're correct. You're correct. Hitler dropped docs. Did he really now, Mama J? Cool. Yeah, danger. We did it, 29 pages. How did the audio hold up? Tell me that it held up the entire time, friends. Tell me it held up. Beast mode audio. Awesome. Post woke world. Oh my goodness, Queen. Hello, beautiful, beautiful Queen. So good to see you, honey. Have you been lurking this whole time? My goodness. Welcome on in, darling. So, what do you guys think? What do you guys think? Okay. Hopefully, what I shared with you tonight was at least interesting, got the brain flowing, got the thoughts flowing, maybe answered some questions, maybe it didn't, maybe it created more questions. I don't know. But I hope it was at least funsies for you. Hope it was. Twizzle Stick wasn't lurking. He's never lurking. Never, ever, ever. Hi, Twiz. How you doing, Twiz? So good to see you. I'm so glad to know that you're always fucking lurking, friend. Always. Where's James Moen? I haven't seen James Moen in here. Where the fuck is he? I drop F-bombs usually just for him. Hope you're doing well, James Moen. Maybe you'll catch this on the replay. Twiz is always lurking, friends. Always. 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 Danger. What do we got? Very interesting. Just sadly reaffirm my thought. Nobody wants to touch this one because they're scared of something. Yeah, I know, right? Seems pretty wild. That's exactly what it feels like. Feels like absolutely no one, including Brian, including Kohberger. They're all like, you know what? Fuck it. We're done. Super, super interesting. Did I get enough sleep, Twiz? No, I didn't. I didn't even fall asleep until like 4 this morning, which is wild. Absolutely wild. Happens like every like month and a half or so. Sometimes once or twice a month, I just can't sleep at all. But I'm gonna sleep like a rock tonight, that's for sure. I fell asleep at like 4 a.m. and then got up at like 6:30 for work and worked my ass off. But it's fine. It's fine. Everything is fine. Lurking and a merkin, you know it. Post, you're still drinking the espresso. Yeah, I do quad, honey. Quad blonde on ice. Quad blonde, baby. I don't even need them to put like anything else in it. I don't want syrups, nothing. It's just straight shots of espresso on ice and then top it off with some salted caramel cold foam. Blueberry, yeah. Yeah, that's how I used to be. 4 hours a day, every day. I could operate on 3 to 4, but nope, not anymore. Nope, absolutely not. Danger. Yeah, exactly. It's been a while. I mean, back in the day when I was a bartender for a while, and back in the day, my God, I used to work till like 2, 3 in the morning. You know, it's fine. I used to stay up all night, sleep all day. I had no kids. I was a bartender and stuff and partying it up, but no, can't do it anymore. I'm old. Same, same post, same, my queen. It's fine. It's fine. Resi Resvi Rofficial. Damn, am I even reading that right? Or my eyes playing tricks on me? I feel like I'm going cross-eyed right now. It's actually because I'm wicked tired and I don't have glasses on. Well, welcome, welcome. You're new to the channel? Well, welcome. I appreciate you being here. Welcome on in, Doc Terry. Yes, I am gonna get a good night's sleep. I am. I'm actually done. I'm done. It's almost 9 o'clock and I'm going to bed. Absolutely. But, I appreciate you guys hanging out with me tonight. I'm glad the audio held up. If you end up being replay crew, go ahead, leave some comments, drop it down below. Let me know what you think. Anything interesting here, anything that maybe stuck out in your brain that I didn't touch on. But, I hope you guys had fun. Hope you enjoyed the chat. I hope you stayed nice to each other and kind to each other. And, Jim didn't fucking show up. Of course he didn't. Of course Jim didn't fucking show up, did he? Right? Of course he didn't. That's okay. I figured he'd never ever show up anyway. It's not a doc. Don't be hating. Don't be hating. This isn't a doc. This is just some of my brainworms, nerdy stuff that I found that I wanted to read to everybody. But if you want to go be replay crew, you can put it at 2 speed. I'm even funnier when I'm at 2 speed, just so you know. So, if you ever wanna get through one of my long lives nice and quick, just put it at 2 speed, and I swear it's actually I'm hysterical. I'm hysterical no matter what I'm saying at 2 speed. I think anybody is. But, I love you guys. Mods, appreciate you. Members, thank you. If you sent a little something to the Cash App, I don't know, I heard my phone dinging. If that was you guys sending things, I appreciate you. It goes straight to the Starbucks Fund, and you know it, okay? I hope you have a great night. Stay safe, and if I don't see you before Thanksgiving, have a very happy Thanksgiving. And don't forget to be humble and try to remember all of the things that you should be grateful for every day, no matter how tiny they might be. And I'm grateful for all of you. Just so you know, Lucy, oh my God, beep, 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 beepity, beep, beep, beep. Hello, right brain. Did you just get here? Oh my goodness. Or have you been lurking too, along with Twiz? I hope you have a very happy Thanksgiving, darling. You, Meg P, Post Woke, Danger, everybody. Love you guys. Mercy Cat, my replay crew queen, love you. Happy Thanksgiving, darling, and I hope you enjoy your gifts for your trip. Good night, everybody. Take care. See you later. Bye. Oh my God, that's right. Congratulations on 3,000 subs, friends. That's you guys. That's not me. That's not me. So give yourselves all of the emojis in the chat. Okay. Pat yourselves on the back. We're 3,000 subs and counting. And that's all you guys. That's not me. That's you. Have a great night, everybody.